All right, Crim 28, let's knock out Chapter 4, Pretrial Supervision, Sentencing, and the Pre-Sentence Investigation Report. So we're covering kind of a lot in this chapter, and this PowerPoint presentation is not that long. Here are the learning objectives. I am not going to read all these, so you can pause this and check them all out. But we're going to start with pretrial services. So what the heck do we mean when we say pre-trial? It is not tricky, so do not overthink this. Pre-trial simply means anything that happens before the person actually goes to trial. And by trial, we're talking about the time when a person actually, we have witnesses, and when a jury or judge finds a person guilty or not guilty of a crime. So this is before a person has been found guilty or not guilty. So is probation and parole involved at this time? Well, parole typically not, but probation more recently, yes. And probation gets involved here typically in pretrial services by way of supervision, pre-sentence investigations, and diversion programs. Okay? So these are some programs that address the entire or the initial steps in the whole concept of pretrial release. The Manhattan Bail Project was the first opportunity for defendants to actually have the opportunity to be released from jail pending their trial. And a lot of times what was done back then is they were assessed for their risk factors, like how much of a risk were they to the community if they were released on bail. Then came the Federal Bail Reform Act of 1966, and this is when specific bail amounts were set for specific crimes. So a lot of people think that judges just kind of randomly pick numbers out of the air for people based on, how the judge is feeling on a certain day. That's not true. Judges would select bail amounts based on a scale that was set by the courts. And then ultimately, the Second Bail Reform Act of 1984 was passed after there was some growing concern about the fact that people were getting released from jail pending trial who were deemed to be still pretty dangerous and violent, and the community was pretty concerned about these people being released from jail pre-trial. So there was more thought put into who was going to be getting released and who was not. Another thing, kind of a side note, because your book doesn't cover it because your book does not talk specifically about California, but in California, within the last 2 or 3 years, California banned bail. Okay, so, but don't take that to heart yet, because there was an order, there was something signed by the governor that said we are no longer going to have bail in California. I believe that was supposed to go into effect in October of, gosh, I think it was 2018. The years all kind of blend together. It was either 2018 or 2019. It did not happen because it's all tied up in legal battles in the courts. But there was a lot of concern among, of course, the bail bondsmen, who that's their livelihood is the bail bonds. But you can kind of understand. I'm not saying I'm for or against it, but at the same time, you think about who is released on bail. People who had the money to get out on bail, right? So a lot of this more pre-trial release type of stuff that we're talking about here, we started understanding the concept that a lot of people really couldn't afford bail, and bail wasn't necessarily fair. So what they started doing was releasing people on pretrial supervision through probation. So a lot of probation officers now are supervising people pre-trial, which is an interesting new concept, a new thought for probation, because typically if you think about a probation officer, you're thinking about a person that is supervising a sentenced offender. Well, that's not the only case anymore. Sometimes probation officers are actually supervising pretrial release offenders as well. And this is happening more frequently now because, again, as you're, I'm sure, very well aware, our jails are very overcrowded. So what we have to do is go in and evaluate the inmates and figure out which ones should be released and which ones should remain in custody. So these are some different types of assessments that are done. The Ohio Risk Assessment System, Pretrial Services Risk Assessments. There are examples of these in your books, page 62, 63, that will give you some examples of what these risk assessments look like. And each defendant will be basically given an assessment, and whatever their result is to that assessment is, they're given a number, a score at the end of that assessment. And from that score, an assessment or a decision will be made as to whether or not they get released. And there are different types of releases. I'm not going to go into all of these. You can get released on an unsecured bond. ROR is released on your own recognizance. Cash or property collateral surety bond. Why are more defendants being detained? I would argue in California that's not happening right now. I think we all kind of know that. And we have zero bail right now. I am recording this during the coronavirus pandemic. So I would be willing to bet that most of you have heard that we are, well, we're obviously dealing with some really interesting, unheard of times right now. So I would argue that at this point in time right now, that is not a significant issue with us. Pretrial supervision, some people are ordered this pretrial supervision. It's a condition of their release. So the judge is basically saying, I'll let you out pending your trial, but you have to agree to the supervision to be supervised by probation. Maybe that's with an electronic monitor. Maybe it's with a GPS tracker. Maybe it's just you have to check in with your probation officer once a week. But in order to be released, you got to sign this document saying, I promise that I'm going to do whatever it is that you're telling me I need to do to remain out of custody. So there are some, obviously, if they fail to comply, they can be warned or they can be taken back to court. If they're taken back to court or taken back into custody, then they do have a right typically to a hearing where the judge will decide either to revoke that pretrial supervision and keep them in custody for until the end of their trial, or they can release them again. I know, it gets kind of frustrating when you're that officer that's doing the pretrial supervision and the person violates their agreement and the judge lets them out again. I would say it does get a little frustrating, but it is what it is. And you just smile and keep on doing your job. Diversion is something else that probation officers will typically get involved in pre-trial. Now, diversion, things like restorative justice, drug court, what do I want to say? It's not military court, veterans court, behavioral health or mental health court. These are courts where a person who is, let's say, well, I'm going to use veterans court as an example. We have a veteran who is suffering from PTSD and he has committed a law violation. He is referred to this veterans court as a diversion program. If he complies with all the terms and conditions and receives all the services, including treatment and therapy for the PTSD, he does not reoffend, and he does everything that he's supposed to do for whatever period of time, 6 months, 1 year, whatever that time is, then his case gets dismissed and sealed as if it never happened. That's typically a diversion program. They're being diverted from the criminal justice system and given an opportunity to avoid a criminal record. A lot of times probation is involved in that, again, pre-trial. This is before they've actually gone through the formal court system. It's an attempt to avoid formal court proceedings. So probation is also involved in that, and these are typically low-risk offenders, relatively speaking. Okay, so that's another way probation is involved pre-trial. So we're now moving on to the sentencing portion. Sentencing does not happen pre-trial; it happens after the trial. So after an adjudication, or after the person has entered a guilty plea or been found guilty, the sentencing takes place. I'm going to kind of... So an interesting thing that a lot of people don't realize is there's typically a probation officer present in the courtroom for every felony sentencing hearing. And somehow, some way, don't ask me how, but the probation officer tends to be the expert in the sentencing portion, meaning calculating what the person's actual sentence should be. And every state is different, as well as the federal government, in how their sentencing guidelines are calculated. Your book has some really confusing, complicated examples. If you'll look on page 71, it has North Carolina. I don't know why they chose North Carolina, but anyways, North Carolina felony sentencing guideline grids are ridiculously complicated and confusing, but these are the kind of things that probation officers do in a courtroom. And their pre-sentence investigation report, which we're going to get to in the next couple slides, is how they do that. And they will make recommendations to the court as to what the actual sentence will be. So we talk about determinate sentencing, which I think we've already kind of covered in this class. And then we do indeterminate sentencing recommendations. And so I'll kind of scooch over that because I think we've already talked about that. And then we have the pre-sentence investigation report. And this is probably one of the most important things that a probation officer does. It is probably one of those things that most of you, a lot of you, when we were doing these discussion questions, you were like, wow, I cannot believe how much the probation officers are actually out in the field. Well, you're right. Most of you are thinking that they spend a lot of time behind a desk. They do. Okay, if you're writing pre-sentence investigation reports, you're spending a lot of time behind a desk. And there are some probation officers that chose to spend their whole career writing these reports. So you do have the option to sit behind a desk all day for your entire career. I did this for probably 8 years, writing juvenile pre-sentence investigation reports. And I couldn't have learned more about probation than I did writing those reports. Now, was it super exciting all the time? Not necessarily. But it was really interesting work. I really enjoyed being out in the field, so I have to admit. So all the super exciting stuff, most of my interesting stories took place in the field, but the pre-sentence investigation reports are really important, and basically they're used first and foremost to help the court make a decision as for sentencing purposes. We make a recommendation. The probation officer makes a recommendation for the judge. The probation officer will write a report that addresses basically every aspect of the offender, the offense, the offender's entire life story, you know, their family, their childhood, their education, their vocational history, if they've been in the military, if they've been arrested, if they've been in gangs, if they have mental health issues, if they have physical health issues, you name it, they put all this information together in a very lengthy, very in-depth report. And at the end of that report, they make a recommendation for sentencing purposes. These reports are also really valuable when the prison or jails are trying to classify these offenders, because they have just a ton of information about that offender in them. It's really informational for the parole board when the parole board is trying to figure out what the offender needed and whether or not those needs have been addressed. It's really, they're imperative for the probation departments when they're deciding who should supervise this caseload, what type of caseload the person should be assigned to, and what type of services that offender should be referred for when they are on probation. These are the types of things that are in the pre-sentence investigation report. They talk about the person's character, external influences, offender's culpability in the offense, Was anyone injured? Prior criminal record, employment history, victim impact statement. This one is also really important so that the judge and everybody involved could really hear from the victim and see how the victim was impacted by the offense. What are some skills? Interviewing. Those of you who are in my classes, especially in Crim 5, and I made you get up and speak in class, it is imperative that you be able to speak to other people, in front of other people, around other people, and be comfortable doing it. Investigating, a lot of you are super interested in this, so I don't worry about most of you with the investigating. A lot of you are like, yeah, you know what's really cool? I want to be a detective. I want to do this. I want to do that. I'm thinking most of you got your social media stalking skills down pretty good, so I don't worry about that. Number 3, writing. Why do we nag you all? Because we don't want you to write a report, have a judge read it, and laugh. And I'm not exaggerating. I've seen it happen before. You do not want to be that person. So when we nag you, your college instructors nag you about writing, that is why. I have seen it happen. If you write horribly, nobody is going to take your writing seriously. So again, when we nag you, that is why. But these are some things that are very important for a probation officer. Anyone in the criminal justice system, a police officer, you write police reports, and guess who reads those? Yeah, everybody. You also need to be able to gather the facts, verify the information, because you can't be putting someone's opinion into your report. It's got to be actual facts. And then present it in an organized and objective format. The only place you really get to put opinion is in your recommendation section. So you also typically will interview the offender, unless the offender's attorney tells you not to, and then you don't interview the offender, which is kind of frustrating. So then you just kind of have to go off all the information you get from other people. Sometimes they're afraid their offender will tell you too much. So every now and then I would get a call from an attorney saying, I don't want you to interview my client before for the probation PSI. Again, so this is all the kind of information you're going to go through and try and get as much information as you can about the offender. Sentencing recommendation. There are pretty specific sentencing guidelines that typically you have to follow in every state. And typically, you're going to recommend a type of a sentence, not an exact length of a sentence. But again, all this stuff kind of varies from state to state. So this is what your book says, but your book wasn't specifically written for California. If you actually are to work for an agency, they're going to tell you how they want you to write your reports. So, what else? Does a defendant have the right to disclosure of the PSI? Yes, they do. They always have the opportunity to review that report with their attorney before they go to court, which is one reason, and I don't know that all POs did this. This was something that it helped me, I don't know, with my own conscience. I would always tell the kids, first and foremost, I don't get to make the ultimate decision as to what my recommendation is. A boss is going to sign off on this. But if I thought that the kid was going to prison for a long time, I would tell them, I think you're going to prison for a long time. I didn't do a lot of sugarcoating. I was pretty blunt and honest with them for the most part. I would say, I think you're screwed. Yeah, I really do. I didn't want to be like, negative and all that kind of stuff. But at the same time, I sure wasn't going to lie to them and be like, oh, you're going to be fine. And then, write this scathing report and tell them, they're going to be locked up for, until they're 50 years old. So, yeah, so they do have a right to review that report before the hearing. Are inaccuracies of that report legal grounds for resentencing? Typically, no. If there's some harmless errors, then typically no, they can just go on the record and say this isn't true, and then the judge says, okay, we'll strike that from the record. If it's something significant that would change the sentencing outcome, then yeah, they have a right, but for the vast majority of the times, no, not necessarily. And then what about other rules for criminal procedure? So basically what your book says is, I like the way this sentence was written. Defendants do not have the same rights as they would otherwise have when they are presumed to be innocent, such as the right to an attorney. So ultimately what they said is no, they do not, other rules of criminal procedure really don't apply to a probation sentencing PSI, pre-sentence investigation report. Sorry, again, each agency calls those different things too. I think Fresno County calls them RPO, report of the probation officer. So, they're called different things by different agencies. It gets a little confusing. I think we've talked about, we talked about this in my other class. So sorry, standard conditions of probation things are things like obey all laws. Pretty much everybody who is on probation has been ordered to obey all laws. That is a standard condition of probation. Now, people who are ordered, people who might be sex offenders might have some different special conditions of probation. Something like don't give out Halloween candy. Don't live near a school. Now, would it be normal for a person who stole a car to be ordered not to live near a school? No, they have nothing to do with each other. So that wouldn't be a special condition for them. So let me back up. Standard conditions, something that pretty much everybody on probation would be ordered, obey all laws. Special conditions is something that's specific for that particular offender or offense. Make sense? I hope it does. That's it.